Good afternoon, everybody. Welcome. I want to thank you very much for coming to our Chancellor's Forum for the Commonwealth Court candidates. We've had a number of forums this year, and they have been really informative and enjoyable, and I thank the candidates for coming as well and participating in this forum. A few things I want to just remind you. One is, of course, to get out and vote, right? It's really important, and as part of that process, we're also welcoming volunteers to assist the young lawyers in going to the polling places where we will be handing out information on the Philadelphia Bar Association's Judicial Commission recommendations. We are embarking on a process to learn about the to learn about the impact on our Judicial Commission ratings. We're working with an e-consult to do this. They're going to help us decide which polling places to hand out the information on our recommendations, and we're going to see if how our recommendation process plays out. So that's important. The other thing I want everybody to know is that PCN is recording this now live, and it will air tomorrow again at 7 p.m. Also want to remind everybody that our quarterly meeting this year is June 2nd at noon at the Bellevue, where we give out the Sandra Day O'Connor Award, and we have the Higginbotham Lecture. Finally, I want to introduce Maida Malone, who is the Executive Director of PMC, and we have had the good fortune of partnering with PMC for this forum and the Superior Court Forum, and without them, we would be at a loss in Philadelphia and in the state. So thank you very much, and here's Maida.
Good afternoon, everyone. Very happy to see you all here today. It's truly an honor for me to be here with so many distinguished colleagues and judges. Thank you all for joining us. As many of you know, PMC has been working tirelessly to create conditions for a statewide judicial system in which all Pennsylvanians come to our courts at any level, whether as litigants, witnesses, jurors, or lawyers, with knowledge of the judicial system and their roles in it, and with confidence that they will be treated fairly, impartially, and with respect. That vision compels us to work for civic education and engagement around the judiciary, equal access to justice, and modernization and reform of the judiciary, including merit selection. While PMC remains firmly committed to moving our Commonwealth to a merit selection process for our appellate judges, while elections remain the means by which we choose these very important judicial roles, we believe that we must do everything we can to ensure that the electorate are as well informed as possible about the candidates and the impact that their decisions make on all of our lives. And it is in that spirit that we are so pleased to be sponsoring this forum with the Bar Association, our great partner. So thank you all again, and it's my pleasure to introduce Carl Myers, who's going to be our moderator today of counsel at Stradley Ronan. Thank you.
Thank you for those wonderful introductions. Again, my name is Carl Myers. I'm an attorney with Stradley Ronan here in Philadelphia, and I wanted to say how honored I am to be here with you today and to have the opportunity to moderate this event with these wonderful candidates. Before I get started, I want to say thank you to the Philadelphia Bar Association and to PMC for hosting this wonderful event. And also I wanted to make a note that this is being live streamed on PCN. It's going to air tomorrow night at 7 o'clock on PCN. It's available on the Philadelphia Bar Association's website. And for those who are so inclined, we have a Twitter hashtag. It's hashtag Decision2017. So please, everybody, get on Twitter immediately and start hashtagging away. The format for this event is a 90-minute forum. We're going to have 1-minute opening statements from each of the candidates. At the end, we'll have a 1-minute closing statement by each of the candidates. And in between, we will have questions. Each candidate will have 90 seconds to answer the questions. The questions are coming from me. I'm the only one that knows what the questions are. The downside of that is that if the questions aren't any good, I have nobody to blame but myself. In terms of fairness, these are going to be questions of general applications that apply equally to all the candidates. And we will be rotating who answers the question first. So we'll go down the line to make sure everybody has an equal chance to answer questions first. In addition, you'll see you have note cards in front of you. If you are interested and so inclined to submit a question, feel free to write it down on your card and bring it to Chancellor Gross here at the front, and we will do our best to try to work those questions in as time permits. So without further ado, we will get into the opening statements, and we'll start with the earliest in the alphabet, or the first in the alphabet, Representative Brian Barbin. Sir.
Thank you, Carl. Good afternoon. Thank you, Chancellor Gross and Mr. Myers for being the moderator, and ladies and gentlemen for being here. I appreciate the opportunity to participate in this Commonwealth Court Judicial Forum, and I hope to provide information today as to why this court is central to our freedoms and what experience it is that ensures the best outcomes to preserve the rights of the people in conflicts with the government and with private interest. I'm the 8th generation of my family to hail from Pennsylvania. The first lived in Buckingham Township before the Revolution. Second lived and died in Philadelphia. The next 5 generations moved to Allegheny City, which was later called Pittsburgh. I'm the first from Johnstown, and I'm here to give you a little information. I'm recommended by the Bar Association. I'm endorsed by the state troopers, the state FOP, the state firefighters, the state troopers, the UMW, the plumbers, and the laborers.
Representative, your time's up. Your minute's up. Sorry.
Thank you.
Mr. Timothy Barry, next.
Good afternoon. My name is Timothy Barry. The jurisdiction of the Commonwealth Court is essentially public, and I have spent 37 years practicing law in Allegheny County in the public sector. I have served as municipal solicitor. I have negotiated hundreds and hundreds of labor contracts involving police, firemen, and public works. I am involved with the Financially Distressed Municipalities Act throughout the Commonwealth of Pennsylvania, including Scranton, Harrisburg, Farrell, Newcastle, Aliquippa, and many more. I am endorsed by the PSCA, the Carpenters Union of Pennsylvania. I am highly recommended by the Allegheny County Bar Association and recommended by the Pennsylvania Bar Association, which said this about me. Timothy Barry has demonstrated a strong work ethic, professionalism, and fairness in his interactions with clients and colleagues. The candidate is known for his integrity, knowledge of the law, and competence. I can't believe they said that about me while I'm still alive.
Mr. Barry, thank you. Next we have Judge Ellen Seisler.
First, I want to thank again the Pennsylvania for Modern Courts and Philadelphia Bar Association for hosting this. I'm Ellen Seisler, and I really sincerely appreciate this opportunity to discuss the court, because it's really hard to get the message of how important the courts are throughout the state. So this is really important, a very important public service. Very briefly, I have been a sitting judge in Philadelphia for the last 10 years. I had the honor and privilege and challenge of sitting for several years in a specialized court where we handled nothing but government agency appeals. So that is when I learned about the Commonwealth Court, handling hundreds and hundreds of cases involving appeals from just a wide range of government agencies. So I realized, and all the opinions I had to write to the Commonwealth Court after that, how utterly important this court is and how profoundly it impacts citizens in Pennsylvania. That's why I'm running.
Thank you. Next, Judge Joseph Cosgrove.
And thank you, Carl, and thank you for this opportunity to speak to the public, to speak to members of the bar, and thank you for getting us all together. We've traveled thousands of miles across this Commonwealth, and we've become friends over the past few months, and it's too bad there were not 5 openings on the court. But there are 2. I'm sitting currently in one of those seats. I was appointed last year by Governor Wolf to sit on Commonwealth Court, so I'm the only person here, I'm the only judge here who is actually serving in Commonwealth Court and has a different perspective on it. doing the work of the court, doing the work that I'm seeking. And today we had oral argument, and I remember every time I go into session, I put on that robe. The robe is a heavy garment, and it's thick, and it should be. It reminds us of the weightiness of the law and our duty. And I'm honored to be in that position, honored to have the Bar Association's highest recommendation. I'm the only Democrat with that highest recommendation, and I'd be honored to continue to serve for an elected term.
Thank you. And last but not least, Mr. Todd Egan.
Well, thank you to the Philadelphia Bar Association and to PMC for hosting this. My name is Todd Egan, and I'm a candidate for Commonwealth Court of Pennsylvania. I am from Scranton, Pennsylvania, but I practice all across the state. After graduating from Dickinson Law School, I clerked for federal Judge Nealon in Scranton, went on to work for Attorney Bob Mariani in Scranton, who's now a federal judge. But since 2004, I'm a partner in a Harrisburg law firm. We have offices in Scranton, Harrisburg, and Pittsburgh. We represent about 35,000 union members all across Pennsylvania. And as an attorney, all of us know that when a client comes to us, it's usually with bad news, and it's with a problem that they have had in their life. So it's really been an honor and a privilege for me to represent working men and women all across Pennsylvania in their really toughest times in their lives. And I want to do the same thing if I'm fortunate to get elected to the Commonwealth Court of Pennsylvania. I want to make sure that individuals get their day in court. Thank you very much.
Thank you. And let's move into the questions. First, we'll start with Representative Barbin. First question is a simple one. Why do you want to serve on the Commonwealth Court?
Thank you. I've spent 35 years practicing law. I practice law every year in front of Commonwealth Court. I'm currently of counsel, and I handle tax cases in Commonwealth Court. I have handled agency appeals for over 20 years. State agency appeals go into Commonwealth Court. Most of them are settled, but some have to be litigated. This court is the place that protects all people's rights. This is the last safety net we have. We have lost a little bit of diversity geographically. We don't have people from the rural part of the state on the court anymore. And we have lost the legislative experience that was once the strongest part of the court. Ted Doyle was a state representative who became president judge. Jim Kelly was a state senator from Westmoreland. They provided an experience that was necessary to know whether or not constitutional rights have been violated, not just in the enumerator rights, but also in the process rights. We've had 3 cases in Commonwealth Court recently that have had to be decided by the Supreme Court and reversed. Those things should have been taken care of in Commonwealth Court, and they would have been aided by some legislative experience.
Thank you. Mr. Barry, same question. Why do you want to serve on Commonwealth Court?
My entire career has been in the public sector, which is the jurisdiction essentially of the Commonwealth Court. And I have always aspired to be a Commonwealth Court judge, but I never thought I would run. I went to the courthouse in Harrisburg 18 months ago, and I saw the portrait of my father, who was a judge on the Commonwealth Court. And I looked at it and I said, okay, Dad, I'll run. And I'm really glad. It's very exciting to be running for public office at this time. There's so much going on. Everyone's paying attention. I think, in essence, at this point in my career, the best way I can give back to the people is to go to the Commonwealth Court. So I'm really glad that I'm running, and hope for the best on May 16th. Thank you.
Thank you, Judge Seisler.
So for my entire career as an attorney, for the last 30 years, I have been involved in helping people, particularly people at risk, particularly vulnerable people, and a lot of that has been in government and government policy. As a prosecutor, as the independent watchdog or auditor for the Philadelphia Police Department, as an investigative journalist for CBS News in Philadelphia, as the director of the fraud unit for the Philadelphia City Controller's Office, as an advisor to the school district on issues pertaining to discipline. I have worked very closely inside government agencies. I have worked very closely or analyzed major policy and governmental issues, and I am very much interested in these government policy issues, and that's what this court handles. It is the only court like it in the entire United States, and this court utterly fascinates me. This court deals with issues that can affect individuals on a very profound basis, a very direct basis. There's a lot of pro se litigants in the Commonwealth that go before the Commonwealth Court. It also handles major issues that can affect every Pennsylvanian, such as voters' rights and environmental issues. So I think this is a natural progression for my work in trying to help people in government policy and in judging. I can combine all of my interests and talents and passion for this court.
Thank you. Judge Cosgrove, same question, although modified slightly. Why do you want to continue serving on the Commonwealth Court?
Well, I appreciate that. And this court, what makes it unique in many ways is that it is a hybrid court. It is equal to Superior Court in rank in our judicial system, but not only is it an appellate court, it's a trial court. And about 15 to 20%, depending on the year, of our docket is original jurisdiction matters. And those cases are important, and many of them are handled at the summary level, the preliminary objections or summary judgment level. So there's a trial aspect to that, which I have a unique qualification for. I've served on the trial bench as well now as on Commonwealth Court itself. So I can understand this in a different way. We only have 2 other judges on the court right now of the 9 commission judges who have also served at the trial level. And that's important that we not lose that perspective, because it's a very important and vital part of our jurisdiction. So I want to continue in that capacity, but my background and my experience has been in the appellate system, not only in the Superior and Commonwealth Court, but the State Supreme Court, as well as the Third Circuit and U.S. Supreme Court. I was second chair a few years ago and filed many briefs, both amicus and merits briefs. So I have an appellate background as well as my trial work as a lawyer for many years and my trial work in Court of Common Pleas. So I'm uniquely qualified for this position, and with your help, I'll stay there.
Thank you. Mr. Egan, same question.
Sure. My grandfather served the public as local district attorney in Lackawanna County and Scranton, and as a Court of Common Pleas judge, and then he moved on to the Supreme Court of Pennsylvania. But he really, growing up, watching him and watching the effect that he had on people's lives in what he could give back to the community as a public service, put a kind of an idea in my mind that if there was an opportunity for me someday to also give back to my community, that I would. And with my practice representing public sector employees all across Pennsylvania, I actually practice more in front of the Commonwealth Court than I do in front of the various Court of Common Pleas all across Pennsylvania. At any given time, I have 3 to 4 cases pending in the Commonwealth Court. I've also, unlike most attorneys, have filed many actions in the Commonwealth Court's original jurisdiction. So when I thought about perhaps running for judge and giving back to my community, the Commonwealth Court was a natural progression for me, because it was a court that I practice in front of a lot, not only in their original jurisdiction venue, but also in their appellate jurisdiction, because I do a lot of work in the various in front of various agencies all across Pennsylvania. So when I made my decision to run for judge, I felt that I could do the most good in the Commonwealth Court of Pennsylvania.
Thank you. And our second question, we're going to start with Mr. Barry. Mr. Barry, your question is, in view of the Commonwealth Court's specialized subject matter jurisdiction, what qualifies you to serve on such a specialized court?
Again, my whole career has been in the public sector, but I actually think I bring a little bit more to the table than that. As Judge Cosgrove spoke, the Commonwealth Court has original jurisdiction. I have considerable trial experience for a municipal labor attorney. I've had a lot of jury trial experience. This, I think, will be very important. I'm very interested in the original jurisdiction of the Commonwealth Court, and I believe that will also help me as a judge. I have had also considerable experience with public sector education law and school law, which clearly is the jurisdiction of the Commonwealth Court. So I bring all that to the table, and really, the Commonwealth Court's jurisdiction, I believe, is such that you have to have a combination of all those skills in order to be a good judge. Thank you very much.
Judge Seisler, same question.
All right, well, first, I've been sitting as a judge for 10 years, and I have proven myself to be able to carry an enormous workload. With one law clerk, I've probably written 500 or 600 opinions in the last 10 years, decided thousands of motions. I'm certainly up to the workload of the Commonwealth Court. I also sat almost exactly in the position of a Commonwealth Court judge for those 2 years that I was handling the agency appeals. I was essentially sitting as an appellate judge and wrote hundreds of opinions, about 80 opinions to the Commonwealth Court. So I do understand the jurisdiction of the Commonwealth Court, the complexity of the Commonwealth Court, and what the fact of the matter is that I also have in my career analyzed and written extensively on very large government issues. I have analyzed large government bureaucracies and broken down big issues related to government, whether it's law enforcement or the school district or the mental health system or the foster care system. These are all the issues that would go before the Commonwealth Court. And the work that I have done shows an ability to absorb and synthesize and understand complicated issues and to get down to the bottom and get down to the truth of these issues. And that's what the Commonwealth Court has to do, and I'm up to the task.
Thank you, Judge Cosgrove.
For the last 28 years, I've taught constitutional law at King's College in Wilkes-Barre, Pennsylvania. I've been an election lawyer for the past 25 years prior to my taking the position on the Common Pleas bench. And these are areas that the Commonwealth Court just thrives in. We deal with constitutional issues. We deal with election issues. You know, this is the court that decided several years ago that the voter ID law in Pennsylvania was unconstitutional. So there's that's my plate that I live on. This is the court that decided, the only court in the country that decided that Senator Ted Cruz was eligible to run for president, although he had been born in Canada, since he was born to an American citizen. We're the only one who solved that perplexing problem with a very detailed opinion. So Commonwealth Court deals with these kinds of complicated constitutional election issues. I've also served as a zoning solicitor. I've served as a solicitor at the county level. I've litigated original jurisdiction matters for legislative caucuses from the Pennsylvania legislature in Commonwealth Court. So I have this background and experience as a lawyer, as a scholar, as an instructor, and also, again, as a common pleas judge and as a judge now sitting on Commonwealth Court. So I'm uniquely positioned to remain in that spot.
Thank you, Mr. Egan.
Sure. So, the candidates, all of the candidates up here have been through some highly vetting processes already. One of the groups was the Pennsylvania Bar Association, and they recommended me for the position for Commonwealth Court judge. We are all Democrats, too, and we went through the vetting process with the Judicial Evaluation Committee of the Pennsylvania Democratic Party. Now, I was the only candidate to end up being endorsed by the Pennsylvania Democratic Party. So we've been vetted twice already from two statewide groups, and I've come through both of those with positive results. But my practice has also, I'm a litigator. Every day I litigate cases in front of either administrative law judges or arbitrators. Anytime a governmental body in Pennsylvania takes action, whether it's a local agency or it's a county or a state agency, those appeals make their way up to the Commonwealth Court. And my practice is 100% devoted to those types of actions, be it a case in front of an arbitrator, a case in front of a hearing examiner, unemployment compensation hearing examiner, workers' compensation judge, in front of a pension issue in front of a state agency. My practice has solely been devoted to issues that eventually make their way up to the Commonwealth Court. So I have a unique understanding of how the record is made in all those agencies all across Pennsylvania. And then eventually, when they make their way up to the Commonwealth Court, they're the court that ultimately reviews those records that I've been involved in.
Thank you. And lastly, Representative Barbin, what qualifies you to serve on such a specialized court?
Sure. Commonwealth Court is the court which will decide important things for people. Number one, they're going to decide what the future of public education is. They're going to decide how health care benefits should be provided and what actions those people providing those services should be required to do if they call themselves a public charity. The special qualifications that I have are 35 years of practice in the Commonwealth Court. I am a litigator. I spent 20 years in private practice, with most of my practice in Commonwealth Court, both original and appellate jurisdiction. I was the state's tax attorney for almost 7 years. I handled matters 16 cases to verdict in Commonwealth Court as the state's tax attorney. I handled 6 in the Pennsylvania Supreme Court. I handled 2 matters in the United States Supreme Court, one involving $700 million potential loss to the Commonwealth. I've served on the Veterans Statewide Justice Task Force, which was appointed by the Pennsylvania Supreme Court, and I have a specialty that no other candidate has, which is a legislative experience which has come from serving on the Judiciary, Environmental and Energy Committee, and Veterans Committee for the last 10 years.
Thank you. For our third question, we'll start with Judge Seisler. Judge, if you are elected, what policies or procedures will you put in place to make sure that all parties are fully heard while at the same time keeping up with the court's workload?
Well, my understanding is the Commonwealth Court has a fairly established policy in terms of when they have argument and where they'll have arguments. So at this point, don't believe I'm in any position to change what's established in the Commonwealth Court. But one thing that I have experienced as a trial judge and handling a lot of opinions for the court and a lot of cases for the Commonwealth Court is first, I think that there should be more published opinions coming from the Commonwealth Court. There's very few published opinions, and both as a judge trying to understand the law and to write opinions, and for attorneys, they have voiced their concerns about it. There's very little precedent. So I think that we should work on getting more published opinions. As somebody who has handled quite a few as a judge who's handled quite a few pro se litigants where their appeals ended up in Commonwealth Court, and I've written opinions, I do find a lot of inconsistencies in the Commonwealth Court and how they handle pro se litigants. I think there should be some more training and standards set in how we evaluate and help these individuals trying to negotiate the system. I think also it might be fair to have more sessions in different locations if possible. They're only in 3 areas in the state. And I know it's difficult for litigants to get to these parts of the state. So it might be worthwhile to open up where we have sessions, and not just in the 3 major cities through the state. So those are just some of the things that I've heard and think could be helpful to all litigants.
Thank you. Judge Cosgrove, same question.
The Commonwealth Court is unique in so many ways. One of the ways is in the fact that we vote on every case. Superior Court or different federal courts, the panels will deliberate after argument, or if it's a submitted case, and render their decision, and the rest of the judges will learn about that when it's issued, whether it's a published opinion or a non-published, non-precedential decision. In our court, we review every decision before it's filed. And if there are 4 of us of the 9 who disagree, even if the panel were unanimous, if we disagree, then that case will be submitted to conference, and we'll discuss at conference, and it may then go to an en banc discussion or en banc argument, which we had today and where I sat today. So that process can tend to complicate things, but it's complicating it in a good way. It means the entire court has had a view of this, and the entire court has had a voice in this, whether the opinion is ultimately going to be unanimous or whether it will be issued with a dissent. But those are important things because that invites then the Supreme Court to take a look at the case and know that we've all had a view of it. I would say the one thing that I think we should do more of is have more oral argument. Unlike Superior Court, sort of the default position is that the case will be argued. All the litigants have to do, the counsel has to do, is just check a box. We would require, if it's going to be submitted on briefs alone, counsel has to file a motion to request oral argument. I think we should have more oral arguments, have that default position like Superior Court.
Thank you. Mr. Egan.
One of the Commonwealth Court is sometimes referred to as the People's Court because a lot of the cases that get heard by the Commonwealth Court involve matters such as driver's license issues or unemployment compensation issues, matters in which the litigants don't have the resources really to hire an attorney, so there are a lot of pro se litigants. And I experienced that when I worked in federal court for Judge Neal, and we had a lot of pro se filings there. So I think one of the things the Commonwealth Court can do is one of the things that I've actually witnessed here in Philadelphia in the family court system, where they have self-help centers for the pro se litigants to come in and are able to look at some basic forms and resources so they can get their actions in front of the Commonwealth Court, because a lot of times the procedures, even for us as attorneys, can be difficult to kind of navigate from court to court. So I think at least, at the very least, we can set up some self-help centers in the 3 locations in Harrisburg, Pittsburgh, and Philadelphia, and then also online, because really it should be about allowing people to get access to have their cases heard by the judges, and procedural things that kind of stymie them from getting in front of judges should be kind of broken down into their basic form, so that even if a pro se litigant wants to get their case heard on appeal, they should have the ability to do that. And I think that's one thing that the court can look at.
Thank you. Representative Barbin.
I think the court does a very good job of handling original jurisdiction matters. They have a great process of pre-conference working out resolutions. This court resolves all of the appeals from any state agency. And you want to be able to use that sort of process to try to get the cases that really have to be decided, and the other cases settled. One of the weaknesses in the current system, though, is there is a tendency to use too many unpublished decisions. And the problem with that is it creates a problem for people. Because if you're not putting all of the cases that are decided out as published opinions, then the common law that you want your lawyer to know and to be able to pass that along to your clients is cut back by these unpublished decisions not being of precedential value. So I think that's the one area we really should work on. The other thing we could do is get more law schools that are local to work with pro se defendants to make sure they understand their rights in the Commonwealth Court.
Thank you. Mr. Barry.
Thank you. I am very interested in the original trial jurisdiction of the Commonwealth Court. And that would be, for example, the kind of case where if you had a lawsuit against the Department of Education and a claim, let's say, against the Department of Education, that would actually get tried in the Commonwealth Court as a trial would be tried in the Court of Common Pleas of the various counties. And that original jurisdiction, I think, can be made somewhat better by looking at the procedures and improving upon them. So that's what I would like to personally get involved with. I would be very interested in presiding over trials in the Commonwealth Court. I think in order for a judge to ensure fairness, the only way that a judge can do that is personally. And I have a disabled son. That has made me a much stronger person, and has certainly made me more patient and certainly more empathetic toward people with disabilities, but makes me more empathetic to everyone, makes me understand how important it is to listen to people, and that's how I think you ensure fairness to everyone, by doing your part and being patient. Thank you.
All right, for our fourth question, we'll start with Judge Cosgrove. Judge, are there any aspects of Commonwealth Court's practices in either its original or appellate jurisdiction cases that you would change and why?
We've talked a lot here about the precedential decision, the issuing of published opinions. The court took one step that at least is positive, but I think it could take other steps. Recently, and not that long ago, the court has issued a rule that allows the citation of the so-called unpublished or the non-precedential opinions for their persuasive value. That was something that litigators did anyway and tried and would say, we understand this is an unpublished opinion and it's not precedential, but you should take a look at it. And the court would always, in a footnote, slap them back but take it under consideration. So now the reality has just been made rule-based. So that's one step. But the publishing the opinions is important. Part of the hesitancy is, as I can see from the inside and know this, part of the hesitancy is that sometimes the analysis of a case is not as deep as one would want to set the rule in a particular direction. Sometimes the case doesn't really call for that. I'm sure Judge Seisler has seen this at the trial level, that not every case has the magnitude that should set a precedent. So that would be one area to analyze those, but I think also developing a different oral argument system and having more on-bank arguments. Those are important. Those are really valuable. And again, with 7 of the 9 judges presiding, I think that we could really set a good trend, and I would hope to see that.
Mr. Egan.
As I mentioned before, the Commonwealth Court is seen, or it's been called the People's Court at times, and I think one of the areas they can improve on is perhaps holding oral argument in areas, and on occasion they do, but most times it's in Harrisburg, Philadelphia, and Pittsburgh. But as an attorney from Scranton, and as some of the other attorneys all across the state, I think it would be easier if they had oral argument in different locations, not only for the attorneys, but also for the pro se litigants. And I think that would not only provide greater access to the court, but it would also allow individuals from the public to come in and view what the Commonwealth Court does on a week when they have their oral argument for the week of any given month. But I think we also all recognize as attorneys the need to have more published opinions, because you're always in search of the case that's on all fours of your particular position. And I think having more published opinions, and I know the court is moving in that direction more and more every day, but having more published opinions also assists the attorneys in trying to figure out actually whether or not they're going to appeal a case also. And in that regard, if there is a case that's published and it's on all fours with your particular case, and you know that your appeal doesn't have merit, it would also provide you, allow you not allow you, but you would not file the appeal, and obviously it would clear the docket up a little bit. So there's many things to improve the court, but I think those two are good examples.
Same question, Representative Barbin. What changes would you make to Commonwealth Court's practices?
Well, one of the things that I noticed when I was practicing daily in front of the Commonwealth Court when I was the state's tax attorney was they have senior judges that they use to resolve. We have maybe 1,000 tax cases a year when I was in the Attorney General's office, and you couldn't litigate 1,000 cases a year. It ended up being about 8 cases a year. But what they would assign a senior judge, Judge Narek used to be assigned. He was a college referee. Perfect sort of person to split the difference. But I think what we could do in court is publish more opinions is a good thing. Get more cases settled that are pro se, that's a good thing. Get pro se some kind of counsel. Dickinson is close to Harrisburg, and Widener is close to Harrisburg. Get those people some law clerks to help them resolve their cases. We'd have less cases that needed to be litigated, would allow more published opinions, and we would be handling a part of our docket in Commonwealth Court that would be better used for arguments on the important issues.
Thank you, Mr. Barry.
I'm going to take a slightly different approach to this question, perhaps a dissenting opinion. I actually believe that the Commonwealth Court is very well run. It's been regarded as being one of the best courts for a long, long time, dating back to my father in the 80s and early 90s. And I'm proud of that. I have had numerous cases before the Commonwealth Court. If a decision has precedential value, it gets published. The only time that a decision does not get published, in which case it does not have precedential value, is when it's essentially a case that does not involve an important public issue, and the court sees no reason to waste paper with the publication of that decision. I don't really have a problem with that. I think the Commonwealth Court actually does a pretty good job administering that whole process. So, and again, I have had numerous cases before the Commonwealth Court, and certainly some significant cases that certainly were published. And I think that is the value of publishing an opinion, is if it does have precedential value, then it should be published. Thank you.
Judge Seisler, what questions or what changes would you make?
I really don't know what to add to all of this at this point. If you want to be perfect, I'm not going to waste my 90 seconds. The fact of the matter is I do believe you need to have more oral arguments. I think there should be some latitude and some flexibility to give more time depending on the complexity of the issue. It's very rigid, and I don't know how they can keep it within that, but I guess they train the lawyers somehow. More published opinions, more accessibility around the state to these hearings. So I really, at this point, don't have much more to add. Okay?
Terrific. For our fifth question, we'll start with Mr. Egan. Mr. Egan, because judges of our courts are elected, campaign contributions are a reality of the judicial selection process. What personal policies would you put in place with regard to recusal when it comes to contributions to your campaign by lawyers and parties who may appear in front of you?
Well, I think number one, there are rules that are already in place, but in amplifying those rules to my particular situation, I would first and foremost, I represent a lot of clients that actually have matters in front of the Commonwealth Court, so that would be the first thing that I would delegate to make sure that those cases weren't being heard by me, or even someone associated with that client would not be heard with me. But we do not, as judicial candidates, we do not solicit funds. So we're not, even though most of the candidates on this panel have received contributions from attorneys and other individuals that are going to appear either as an advocate or a party in front of the Commonwealth Court, I think there has to be more than that relationship, because whether you agree with electing judges or not, the reality of the situation is we are electing judges. And all judicial candidates are going to accept contributions from attorneys that practice before them, if not most. But I would definitely establish rules that would make sure that any individuals that I had a relationship with prior to running for office, either as a client, or obviously a family member, or some type of other connection, I would make sure that I would not hear cases from those individuals.
Thank you. Representative Barbin, same question.
Yeah, I think the much better question than whether you elect a judge is whether or not you get the state legislature to finally take up campaign finance reform. We have canons of ethics as an attorney, and we're supervised by the Pennsylvania Supreme Court. We have provisions that say that if you receive a contribution of more than $250, you should consider recusing yourself in an individual matter. We have rules to handle the situation as it is. But the situation as it is something that no one should be proud of. Campaign finance reform is necessary on all levels of government, whether it's the executive and it's the governor, whether it's the legislature, or whether it's the judiciary. So that's where you make this better. It's a much more important issue to deal with than whether we elect judges or not.
Thank you, Mr. Barry. Same question. How would you deal with recusal in light of campaign contributions?
Most of the people that contribute to a judge's campaign are lawyers. And I don't think that there's anything wrong with a lawyer saying that I think that this person will be a good judge. I don't think there's anything wrong with that. And certainly, again, we have judicial canons of ethics which already address the situation. But lawyers, I believe, can contribute to a judge's campaign without there being a problem. My personal view, which has always kept me out of trouble, is that if I even think I have a conflict, then I probably should recuse myself. Because if that thought even comes into my head, then there must be some reason why I believe that that it would be better for all concerned that I would recuse myself because of the appearance of impropriety or conflict. Thank you.
Thank you. Judge Seisler, same question.
That is probably one of the most compelling reasons for merit selection, is because we're put in a position of having to run a campaign and to have people vote for us, and the only way to get your name out there is to have the funds to put your name out there. So it's, personally for me, a despicable situation to have to raise money to become a judge, and I think that by its very nature, and I'm not a politician, and so, you know, my staff tells me, Ellen, why do you say that? I'll tell people, you know, if you really think I'm going to be a good judge, you shouldn't give me any money because I'll have to recuse myself. And they don't want me to say that out there. But the fact is, we don't have a choice. I'm uncomfortable with it. If people donate a certain amount to me that, you know, is a lot, there would have to be an automatic recusal because the public perception would be that I couldn't be fair and impartial. There's a certain threshold. Anything below that threshold, and I don't know what that is quite yet, you have to disclose it to anybody. I don't know how much money it is. You have to disclose it to all the parties, and then you internally, or I internally, will know if I can be fair and impartial. So it's just a sad fact that we have to raise money, and I'm not happy with it. But if I felt that it impacted the public perception or my ability, I would absolutely recuse myself.
Thank you. Judge Cosgrove.
I'm in the unique position of having been merit selected for the position I'm in. And that was a rigorous process that Governor Wolf had established. He had a commission, bipartisan, lawyers, non-lawyers, stakeholders in the community, and that commission analyzed all of the applicants and the candidates. I believe there were 46 for these positions, and from that I was recommended and the governor chose me, and then the Senate controlled by a party other than the governor's, and I was unanimously confirmed. I didn't have recusal issues with that. When I got to Commonwealth Court, I did have to disclose to our clerk any lawyers that I had a particularly close relationship that I'd practiced law with, things like that, clients that may appear before the court. They're on an automatic recusal list. So for the first 6 months of my term, I did not have to deal with the issue that this question poses. But now I do. So I deal with it as all these candidates are, but I'm, again, in that unique position that I'm not looking at it as what I will do, it's what I'm doing every day. I analyze the donors, I look at the donors, and I check every day when I'm reviewing those opinions that I must vote on. I check to see who the lawyers were the parties there, and if there's a conflict, I recuse. If there's not, I proceed. But it is a process that things like this, a forum like this, having these all over the state by nonpartisan groups like this would be a really big help.
Thank you. And for our sixth question, we'll come back to Representative Barbin. Representative Barbin, what, in your view, are the most significant recent Commonwealth Court or Pennsylvania Supreme Court decisions, and why?
Okay. I tried to get into this in my opening statement, but 1 minute really wasn't enough. The three most important cases that have been decided in this Commonwealth came out of Commonwealth Court and were reversed by Pennsylvania Supreme Court. One was the voter ID case. That case should have been thrown out at the first level because it was about taking a requirement which was reasonable on its face, but as applied was a bad way of doing it. Voter ID was 400,000 seniors are going to lose their right to vote because there's a requirement in the law that says You have to have a raised birth certificate seal. People that were over 80 years old were not going to be able to go through the hassle of getting the birth certificate to get the ID, so they basically were saying, we're not voting. That's wrong. That violates the constitutional right to free elections. Should have been thrown out at the Commonwealth Court level. Justice Castile cast the deciding vote 4-3 and reversed it. Voter IDs out. Second case, gerrymandering. No more important thing that you have in this Commonwealth than free elections require no gerrymandering. Same thing happened. Last thing happened, fracking. Energy was two subjects put together. Law says on the process you can't do that. They threw it out at the Supreme Court level.
Thank you. Mr. Barry.
As I said, I've had many cases before the Commonwealth Court, very interesting cases involving cases of first impression. The one case was whether home rule municipalities in Pennsylvania, whether the state pension laws apply to home rule municipalities. That's the kind of case that goes to the jurisdiction of the Commonwealth Court. And the court ruled in my favor that the pension laws do apply to home rule municipalities. I've also litigated cases involving the legality of cyber charter schools, which of course is a big issue. That's again a good example of the kind of case that will go to the Commonwealth Court. I also have been involved with financially distressed municipalities, and that case has gone to the Commonwealth Court twice concerning the legality and constitutionality of the Financially Distressed Municipalities Act, whether or not that conflicts with Act 111, which is the state law that deals with police and firemen bargaining rights, whether that state law for financially distressed municipalities supersedes that act. And again, that was a constitutional issue. So I think those are all very interesting cases.
Same question, Judge Seisler.
So now I insult the moderator right now. The fact is, we get asked that question a lot, and every case is important. Every case that goes before these courts, the Supreme Court and the Commonwealth Court, and I've read a lot of them, and I've written quite a number of them, they're extremely important to the litigants, and they're really extremely important to the case law that they're building upon. So I don't like to boil it down to any specific case, but I can because, I'm asked to do it. The case I'm really waiting for is the education funding case. The Commonwealth Court threw that out on preliminary objections. It's a critical issue for the entire Commonwealth, whether how we fund our schools is constitutional, rational. Commonwealth Court threw it out on preliminary objections, and I'm waiting for the Supreme Court case to hear it. The Commonwealth Court had a number of cases involving the pipelines, and they did not find in favor of the litigants in those cases, the homeowners. The Supreme Court has found that a number of the provisions of the Gas Act, I don't have Act 13, were unconstitutional. The voter ID was originally thrown out by the Commonwealth Court. It was found reversed by the Supreme Court. So, the bottom line is every one of these cases is important, and every one of these cases deserves fair and thorough and careful analysis. Sorry.
Fair enough. Fair
Okay.
enough. And I don't disagree with that. Okay. Judge Cosgrove, same question for you.
One of the most important decisions last year involved all levels of our government and the people themselves and how we self-govern. And that was the case involving the question of whether the proposed constitutional amendment that raised the mandatory retirement age for judges from 70 to 75, and whether the procedure that the legislature had implemented was appropriate, constitutional, and whether the question could go on the ballot. If you remember, there was an awful lot of political dynamic behind all this. The amendment was supposed to be on the spring ballot a year ago, and then the legislature pulled that all kinds of discussion as to why, the question of whether it could be pulled, whether it was appropriate, or whether it should have been decided in the spring, in the primary season. That was before one of our judges with a single judge decision. Ultimately, it was decided that the amendment could go on the November ballot, and it did, and passed with a very small majority, but passed nonetheless. Well, regardless of whether you think it was a good idea or not such a good idea, that's going to impact us for a long time. It certainly impacts us here because there would have been 3 rather than 2 seats on Commonwealth Court. The other major decision in the past few years has been the Robinson Township decisions, a series of decisions that have greatly expanded the perspective of the constitutional rights amendment that is part of our Constitution, dealing with fracking, dealing with pipelines, and other things.
Thank you. Mr. Egan.
Well, usually when I've been going last on this panel, it's been really good. But now that I'm last, there's not a lot of cases left for me to talk about. So maybe I'll just say ditto. But let me just echo some of the things that have already been said, because I think as I said earlier in one of my answers to my questions, when somebody comes to you as a lawyer, it's the most troubling and difficult time in their lives. So for those individuals, every single case that goes to the Commonwealth Court is important. But if I had to pick 3, I would probably pick the voter ID law that actually, after it went to the Supreme Court, came back down to the Commonwealth Court, and it was ultimately one single judge on the Commonwealth Court that ended up hearing evidence and striking that law down. The other case that I would also bring up is gerrymandering, because when you have a situation when you have the districts in the shape that they're in here all across Pennsylvania, not only the congressional districts, but the state representative and the state Senate districts, I think we have a real problem here in Pennsylvania with having proper representation. And then the third case, I think, is the Robinson Township case, the fracking case, because that case that came out of the Supreme Court, in essence, resurrected that constitutional provision that provides for clean air and clean water. And I think that's a decision that's going to resonate not only for us, but for our children and our grandchildren in years to come.
Thank you. For our 7th question, we will start with Mr. Barry. Mr. Barry, given the Commonwealth Court reviews decisions of state and local agencies, what is your view of the degree of deference that the Commonwealth Court should have as to agency decisions it reviews and the agency's interpretation of statutes?
I believe that the standard for reviewing those cases is pretty well established. Whether there's substantial evidence to support the findings and conclusions of law of the state agency, the court would review that to see if there is an error of law or if there was an abuse of discretion, and I believe that the standard is already, again, pretty well established. The court normally will give some deference to the decisions of a state agency, but I think that's rather limited. Certainly in areas such as environmental issues, as far as I'm concerned, a court should give very little deference to decisions and should independently review environmental issues to make sure that not only the law is being complied with, but our Constitution. And there's other examples of that. I think whenever you have a constitutional issue, and the Pennsylvania Constitution, interestingly enough, has a lot of the same provisions as the federal Constitution, but there are a lot of things in the Pennsylvania Constitution which I am very familiar with that are not in the federal Constitution, and you really have to pay attention to those, and there should not be any deference in those areas. Thank you.
Judge Seisler.
Mr. Barry did adequately cite the standard of review, and it's pretty well set. And I did handle hundreds of agency appeals for my county, and I understand the standard of review, which is to ensure that that the findings of fact by the trial court are supported by substantial evidence, they didn't commit an error of law, or that the trial judge or the court did not have a manifest abuse of discretion. So that is the standard. The important thing for the judge, and particularly at the Commonwealth Court level, is that these agencies are overwhelmed, these boards are overwhelmed, and even the trial judges at the common pleas level are overwhelmed. So what you need and what you want, since you're almost at the last level of review here, because very few cases are going to make it to the Supreme Court, you're going to want a judge who is going to give each case a careful and thorough review, and that means reviewing the entire record, the briefs, the opinions, the exhibits, the transcripts, the photographs, everything, and really giving it a final review. For most people, this will be their last chance. So that's what I've done as a trial court judge, and I intend to do that with even more emphasis and more importance, because I understand that there's going to be very little options after that.
Thank you. Judge Cosgrove.
At this level of review, it's all about the record. That's what appeals are. It's all about the record. It's the four corners. It's, as the Prothonotary office says, if it's not in the box, it doesn't exist. So if it's not in the record, it doesn't exist. But fellow trial judge and fellow trial lawyers here at the table, they all know that the agency record is not the same as a trial record, for example, in a criminal case or in a civil personal injury or other case like that, where lawyers are litigating and there are witnesses and there's exhibits and there's all kinds of detail and the record can be voluminous. Oftentimes at the agency level, that record is terribly sparse. Deference, yes, we know the standard. We know that three-pronged standard. But I've heard it said, when a court reviews a lower court opinion, it cleans its glasses and it looks carefully. When it reviews an agency record, agency decision, it still cleans its glasses, but it wears bifocals. We are the first court. We are the first independent judicial body to review an agency, a different branch of government's actions. And so that must be taken quite seriously. We have different standards. We have different ethics. We have different rules that guide us. And that must be taken into consideration.
Mr. Egan.
Well, as the Commonwealth Court reviews cases from state agencies and even local agencies, you have to understand that even though the standard is that they're supposed to give deference to those agencies because they have expertise in those particular areas, whether it's the Pennsylvania Labor Relations Board or whether it's the Workers' Compensation Appeal Board, because the law says that they have expertise in those areas. I don't necessarily believe that because, like it or not, those agencies have been overwhelmed with the number of appeals that have been coming up through the system. And as the state budget gets tighter and tighter, their staff levels go down. So like any agency, like any court, mistakes are made. So when you sit as an appellate court judge, you're sitting to review the record, even though you're supposed to give due deference to the agency because they have expertise in that area. I think you have to review the record carefully. And I think you have to make sure that when you make that final decision at the Commonwealth Court level, because it is the last court of automatic appeal. You're not going to automatically be able to take your case up to the Supreme Court. So this may be the court of last resort for those individuals. So deference or not to the state agency, you have to get it right, and I think you have to review the record carefully.
Representative Barbin.
I look at it a little differently. I was the state's tax attorney for 7 years, and I think that when we talk about deference to a state agency, you have to remember that it's in context. The rules are very simple. Before Penn got here, he sent a charge to the legislature. He said 13 words. You shall be governed by laws of your own making and live free. The laws are pretty simple. They're what they are. Whatever is passed by the legislature, signed by the governor, that's the law. The regulations are only valid if the regulations are consistent with the law. When I was young, I learned Commonwealth versus Reby said a regulation can't be an extra from the law. It can't be in opposition to the law. The only time that happens is with a state agency that says we're gonna make a mistake, and then the mistake is in the favor of the person who brings the case before the court. Deference is only appropriate if it's consistent with the law. We got the greatest system of law the world's ever known. We have to use it, but it has to be consistent with the law, and we have to hold the agency to the law.
Thank you. For our 8th question, we will start with Judge Seisler. Judge, please tell us what you have done throughout your career to support diversity in the legal profession, and what would you do, if anything, to support diversity as a judge on the Commonwealth Court?
What I have done to support diversity as a lawyer?
Sure, yes.
Well, first of all, I've always, just as a judge, I have surrounded myself with all of my clerks and interns and fellows with people from backgrounds and races and religions and countries of origin. So I've had a very interesting staff around me as a judge, and I think that's very important for me, for my own perspective, for my own growth, for my own understanding and development. So that's what I've done as a sitting judge, and I will continue to do that if I'm elected to the Commonwealth Court. My background as an attorney has been mostly in government policy and auditing, and so I have really been pretty isolated in my profession in the last 30 years, whether it's been as an investigative journalist or the independent auditor for the Philadelphia Police Department, or the director of the Special Investigations Unit for the City Controller's Office, or a prosecutor handling domestic violence cases. The bottom line is I don't have an opportunity to create diversity in the workplace, but I do have the opportunity all the time to treat everybody, no matter who you are, with the same amount of respect and dignity that I would want for myself.
Judge Cosgrove.
When I was appointed to the Court of Common Pleas, I actively sought out from the minority communities throughout the state and throughout the country law clerks. I've hired the first African-American law clerk in Luzerne County in 150 years. It was sad to recognize that that had been the case. We had a law clerk in the 1850s who was denied admission to the bar because of the color of his skin, but he had clerked with the court. And we changed that, and we admitted him to the bar posthumously. I've worked with civil rights groups for the entirety of my career. One of the highlights of my career was working with Cesar Chavez in the United Farm Workers in California. I had the touching honor to sit with him during his last fast. He was famous for his fasts for justice. He was fasting over the mistreatment of the agriculture workers in California, and I sat at his bedside during that time alone with him. So I have fought for the civil and human rights of everyone. Our court needs to do more. How we do that, it's very difficult to say. We need to openly recruit. You know, this is a problem that the U.S. Supreme Court deals with. I don't believe now, at this point, I'm not sure there's any African-American clerk at the U.S. Supreme Court. At least there had not been until recently. We need to do more in our active recruiting, working with those agencies. There's a group called CLEO that is active in helping with those recruiting processes, and I worked with them previously. We need to do that as a judiciary.
Thank you, Mr. Egan.
Well, my diversity in my law practice also stems into my diversity in my individual life. You know, I've represented a woman when she was fired, when she went on maternity leave, and I had the very first jury verdict under the Family Medical Leave Act in the Middle District of Pennsylvania. I've represented 4,000 state employees in a class action under the Americans with Disabilities Act. I've also represented an individual before marriage equality was the law of the land in helping her get health benefits from the state for her and her same-sex partner. So I've shadowed what I've done as a lawyer, not only in my law practice, but also in my individual pursuits. For example, as a young lawyer, I was involved with the Bar Association in Lackawanna County, where we had job shadowing, and we pushed to include minorities in that job shadowing to give them really the insight into the legal profession. I also have been actively involved in junior achievement of Northeastern Pennsylvania, where we go into the classrooms, all different classrooms all across the county, and we talk about business, and I put a particular spin about the legal profession on that. So, and we try to actively involve minorities in that effort. So what I've done as a lawyer has also been, I've also shadowed that in my individual efforts outside of the courtroom.
And now, Representative Barbin, your turn.
Thank you. I look at this question a little differently, and the question for me is always, you got to start with the beginning. We're all immigrants. Every single one of them. 9 generations of my family, they're immigrants. They all believe in God. And God gives you the chance, and this is how we got to where we are today, equal dignity under the law. It doesn't matter who you are, you're supposed to be looked at the way God would look at you. If you do, these questions all get resolved. From my perspective, it's much more important for a judge to be able to say, I'm going to follow the law that we got from the Old Testament, because that's how we got here, and that's how we established our laws. They started with religious liberty, they allowed civil liberty. Leviticus 15 says you shouldn't show partiality to the weak, nor should you show deference to the mighty. The issues are best resolved when you sit there and you have to say, if I believe in God and I got to explain it to God sitting beside me, how would you decide things? That is what needs to be done in this country.
Thank you. Mr. Barry.
I'm very proud of the hiring decisions that I have personally made during my life, where I have hired a considerable number of lawyers who are women and minority women. And quite frankly, it's just the way I was brought up. I'm very proud of the way I was brought up. I come from a family of 8 children, 4 boys, 4 girls, of course. And, you know, that's just the way it was. And my parents both, they raised us to respect people and certainly respect human rights and civil rights. 18 months ago, in August of 2015, I represented a waitress in a Title VII sexual harassment lawsuit in federal court in Pittsburgh, in the Western District, and the jury returned a verdict in her favor. That's all I'm allowed to say about that case because of a confidentiality stipulation, which is probably good because I'd talk about it for quite some time. So we'll let it go at that. But listen to what I just said. Timothy Berry, sexual harassment, Title VII lawsuit. It's out there. And that case was all about respect for women. And that case was all about women's rights. Thank you.
Thank you. And for our final question, this will be a lead up to our closing statements. We'll go to Judge Cosgrove. Judge Cosgrove, what about your resume and background do you believe truly sets you apart from all of the other candidates, such that you believe you deserve our vote?
I've had 2 governors who dealt with vacancies. They could have chosen any lawyer to fit within the jurisdictions to fill those spots. I was appointed, nominated, and then both times Senate controlled by an opposing party unanimously confirmed me. The first time was in Luzerne County after the infamous Kids for Cash scandal, which is still staining our judicial process. And I was asked by Governor Rendell, he had a simple mandate, go and restore the integrity of the judiciary. Well, not a small task. But myself and my 2 colleagues who were also appointed shortly after, we did that. And then when another vacancy occurred on Commonwealth Court, I was asked by Governor Wolf to serve, nominated by him out of all the individuals, all the lawyers who had applied, and he chose me, and the Senate from another party unanimously confirmed me. The Pennsylvania Bar has, among all of the candidates on the Democratic side, I'm the only one that is highly recommended, the highest recommendation from my peers at Pennsylvania Bar, and I'm honored by that. The Democratic Party, although I was not endorsed, I finished second in the balloting, but the committee that was established that did the interviewing picked Todd and myself and chose me. So anytime I've been vetted, I've been picked. And I'm asking for the major vet, and that's the voters, to vote for me.
Mr. Egan.
Well, experience matters. And I think if you look at the experience of the candidates, not only on the Democratic side, but on the Republican side of this ballot, I think that I lead in the experience on the Commonwealth Court. We talked earlier about the deference that the court gives when it's reviewing agency matters, and think about how those agency records are created, because I've been involved in all of those. And I truly understand how the records are created that eventually make their way up to the Commonwealth Court, whether it's in front of an arbitrator, whether it's in front of a hearing examiner, a judge, an administrative law judge. I've been involved in all those types of cases, so I truly understand the nature of administrative actions here in the Commonwealth Court of Pennsylvania. So when those records make their way up to the Commonwealth Court, I'll be in a unique position to understand not only the law behind those records, but how those records have been created. In addition to that, I handle many cases at any given time in front of the Commonwealth Court of Pennsylvania, not only in the appellate court jurisdiction, but in their original jurisdiction. So when it comes to experience matters. And I'm the candidate that has the most experience, the proven background to do this job.
Representative Barban, what sets you apart?
I have experience in all three branches of government. I was a judicial clerk coming out of law school for the Chief Justice of the Pennsylvania Supreme Court. I was a Deputy Attorney General who handled matters in the United States Supreme Court. I've spent the last 5 terms in the State House. I passed 4 bills. I've made some bills a little better, and I've objected when I thought bills were unconstitutional. I have an experience that sets me apart because I believe in the system. I believe the system is missing one thing. It's virtue. The republics, we're a republic. We are required to have virtue in order to make it work. It's what was missing at the end of the Roman Republic. It's missing now. I have a son that taught me what is missing. And this was before Hebrew text was put down in the Torah. This was a symbol to explain what was necessary for a government. And what's necessary is, it's not our story. It's God's story. And our part in it is to make sure that we respect the system by loving our neighbor as ourselves. It's also in the Liberty Bell, Leviticus on the Liberty Bell. It's also in the flag that's raised at Iwo Jima. That person's from Johnstown.
Mr. Barry.
I've already told you about my qualifications and experience, and I believe that there aren't too many attorneys in Pennsylvania who have my municipal experience, my public sector labor and employment experience, my experience negotiating hundreds of labor contracts, my financially distressed municipalities experience. And the other thing that I have done in the last 5 years, which I did not tell you about, is I am a labor arbitrator, which has certainly given me experience dealing with deciding cases and being neutral as opposed to an advocate, which I think is quite different. And it's taught me patience. The reason why I would vote for me and the reason I will vote for me is because of my life experiences. I've already told you about my mentally disabled son. That has made me a much better person. I can't compare myself to other people, but I can certainly compare myself to the way I used to be before that happened to my son. And I can just tell you that I'm a much stronger, more patient, and understanding person than I used to be. And I really think that those qualifications and the temperament to be a good patient judge, that I have those qualities. Thank you.
Judge Seisler.
So again, I'm the only person running who's been an elected judge for 10 years, and was rated qualified back then. I'm rated qualified now. But the fact that I'm here, the fact that I'm even running for this position from what I've come from and what I've overcome in my life, for me is pretty remarkable. And I think I'll bring a perspective to the court that no other person running or sitting has. And what most people don't know about me is I grew up under extreme poverty. I had a mother who had 3 children before she was 21 years old, and our father abandoned us, and my mother had little work experience and education, and she tried to raise us on minimum wage jobs and essentially was not able to raise us on minimum wage jobs. My family lived on the brink of homelessness for years. We didn't have health insurance, and I had a very seriously mentally ill sister who had drug addictions. There was a lot put on my shoulders at an early age. Starting at the age of 14 and 15, I had to go to work to help my mother keep a roof over our heads. I put myself through a community college in Montgomery County. I put myself through Temple undergrad and law school, and I've done it on my own. So I am really amazed and proud at what I've overcome, and I do believe that my background and what I have done with my with my law degree and how I've helped people over the years and the organizations and nonprofits that I've been involved in, I think that I'm going to bring the kind of empathy and understanding for everyday people. You keep hearing that this is the people's court. Well, I understand the people, and I will be a good judge on that court. Thank you.
Thank you. And now we will turn to the closing statements. So the candidates will get to say whatever they want. They don't have to respond to one of my questions. And for the closing statements, what I thought we would do is we would do the inverse order this time. So we'll start with Mr. Egan, and then we'll work our way back towards me. So each of you have 60 seconds to say whatever you'd like to entice the voters to vote for you. So Mr. Egan, why don't you start us off?
Sure. Well, let me say thank you again to the Bar Association and to PMC for hosting this event. When I graduated from the Dickinson School of Law in 1996, I went on to clerk for Judge Nealon in Scranton. I did a 1-year clerkship with him. And then I had to make a choice on what I wanted to do with my career. And the choice that I made was to represent individuals, was to protect women's rights, to protect workers' rights, to protect the rights of individuals with disabilities. And that's what I've done, that's what I've chosen to do over the last 20 years. You know, a lot of candidates get up and they talk about protecting rights, protecting individuals, protecting constitutional issues, but I've walked the walk. I've been there. I've been doing it for 20 years. And I'm running for Commonwealth Court because I want to continue to do that. I want to continue to make sure that due process is filed. I want to continue to make sure that equal protection under the law is followed. And I appreciate your time here today, and I thank you very much for your time. Thank you.
Judge Cosgrove.
Thank you, PNC. Thank you, PBA, for hosting this. Thank you, PBA, for your high recommendation of me. Going to work every day on Commonwealth Court is the highest honor I could have as a lawyer in this profession. As an advocate, I knew I was always right because I was representing my client, and I took the phrase, represent zealously your client, to heart, and I did. Fought the fight all over the country. Now it's even more important that I get it right, because the only client I have is the Constitution and the people. That's a pretty daunting position to be in, and it causes me to take a breath every moment before I render that decision. I've done the job. I'm doing the job. With your help, I'll continue to do the job, and I'll have the honor of serving with one of these good people next to me. Thank you, folks.
Hopefully.
Judge Seisler.
Listen, I'm a full-time judge and running for a statewide office. This is not, you have to understand, I am passionate about the issues before the Commonwealth Court. This is a daunting challenge. It is overwhelming, but I truly believe in the importance of this court. I am passionate about the constitutional and governmental policy issues that this court will face. I've had the experience to do a good job, and I also do believe that we need more geographic diversity on this court. This is a government policy court, and there is nobody elected on the bench who's from Philadelphia. And I really do believe we need that large urban perspective, someone sitting on this court. But I think you've heard enough about my background and my experience that you can understand that I'm qualified, but just know that I'm doing this because I am passionate about protecting all Pennsylvanians and representing our state on this very important court. And thank you for your time.
Mr. Barry, your 60 seconds.
Thank you very much to everyone. I really enjoyed this presentation, and I think I've told you enough about myself, so I'm just going to tell you a little story. I just think it's an interesting story. In 1983, my father ran for the Commonwealth Court. And on St. Patrick's Day in 1983, somebody picked for him the #1 ballot position for the Democratic Party. This year, they were supposed to pick the ballots on March 15th. And I was actually here in Philadelphia at the time, but the snowstorm hit. And they moved it from March 15th to March 17th. And they picked the ballots on St. Patrick's Day. Guess who got the #1 ballot position? So I give my dad credit for that one. That's all I got. Thank you very much.
And lastly, Representative Barban, your 60 seconds.
Thank you. It's been a pleasure to be here tonight and have an opportunity to speak to voters. This is the People's Court. I am proud of all of the generations that have come before me. No one's been powerful. No one's been rich. They did their duty in all things. You can't do more. You don't want to do less. That means, what that means is, God, you're accountable to God. I think with my experience, 35 years, this is a good place to protect people's rights. That's why I'm running for the job. I was a union construction worker. I think that matters. I'm the only guy that really can carry Portland cement or drywall. You need to know what hard work is.
Well, thank you. Let's hear it for our candidates. Thank you all for joining us. Thank you all who are watching or who are listening. For those in the audience here, we're going to have a wine and cheese reception out here. You're welcome to stay and speak to the candidates, who I'm sure would love to speak to you. Otherwise, you're all free to go. Thank you for joining us. Appreciate it.
Great job.